At UN talks in Switzerland, more than 190 nations have agreed to a new treaty to combat so-called biopiracy. It refers to corporations using patents to lock up natural resources and traditional knowledge of Indigenous peoples without compensation.
The vast Amazon rainforest, home to the greatest biodiversity on Earth. 1 in 10 known species lives here, and a new plant or animal is discovered every 2 days on average. The biodiversity in the Amazon and other rainforests has provided humankind with plenty of valuable resources, such as rubber, latex, coffee, cocoa, and ingredients used in medicines and cosmetics. In many cases, the people who lived among these plants knew of their usefulness and were utilizing the resources before European explorers arrived and began to exploit those goods on an industrial scale, patenting their so-called discoveries without regard for the indigenous people whose intellectual property it is. The age-old practice has become known as biopiracy. Thanks to a new United Nations treaty, there's now a legal framework in place to fight it.
And for the first time ever, we have a treaty that connects the global IP system with the wisdom, heritage, and richness offered by indigenous peoples and local communities in the form of their genetic resources and associated traditional knowledge.
For a current example of biopiracy, take the psychoactive plant mixture ayahuasca. In the 1980s, an entrepreneur from the US patented one of the plants used in the brew, despite the fact it had been used for centuries by indigenous healers in South America. In the Amazon region, in South America in general, we use a medicine, a plant well known throughout the world, known by its name ayahuasca. There are many laboratories that want to do research on this plant to treat people with psychological problems, mental problems, and many pharmaceutical companies in various parts of the world want to take ownership of this plant to make medicines. Under the new treaty, anyone looking to patent an invention based on traditional indigenous knowledge, such as ayahuasca, will be required to disclose their source. But the treaty does not address compensation for those communities.
I asked Amber Hartman-Scholz from the Leibniz Institute exactly how the treaty will benefit Indigenous peoples and biodiversity.
Yeah, it's a great question. The major impact from this treaty will be that when a patent applicant, so a company that applies for intellectual property rights, if they use biodiversity or if they use traditional knowledge, they will have to declare that as within their patent application. So to date, if you can take something out of a rainforest, in the patent system, you wouldn't actually have to disclose where that came from. So this treaty now makes that connection between the use of biodiversity or traditional knowledge and saying, I use this as part of my invention.
Okay, so it'll have to be put in ink, but does that have any ramifications?
Well, it does. I mean, if you don't do it right, then your patent's not validated. And if your patent's not validated, then your ability to be able to make money on your invention is also limited. So this connection between other laws and under the UN Convention on Biological Diversity that have said for, let's see, a decade now, you have to ask permission before you take something from another country in terms of biodiversity, now moves a step further down the value chain into the patent system, where the relationship between the validity of your patent and that connection back to that original, removing the sample, removing the orchid, removing the microbe from the forest is made. So that value chain kind of connects now with the decisions made in Geneva yesterday.
But will it also equate into some sort of compensation for Indigenous people?
Ideally, although the treaty itself doesn't do this, the treaty basically says you patent applicant must disclose what you used in order for a practitioner skilled in the art to reproduce the invention. However, the idea, the principle, and the reason I mentioned the Convention on Biological Diversity earlier is that there are rules under that environmental condition that say you can't take something from another country, from a sovereign state, or from an indigenous people without asking permission first. And that contract, at the very beginning of the research and development phase, if you will, there, the country or the indigenous people can say, well, if it comes someday to royalties or to money or licensing or a patent application, then I think I deserve 5%, 2%, whatever number the two parties agree with. And so this is basically a legal checkpoint at the very end of the value chain that enables the full realization, if you will, of the original agreement that could have taken place at that point of sampling, at that point of the beginning of the research.
Amber Hartman, Scholz from the Leibniz Institute.